Welcome to LexTalk, World's talk show presented by ClickAway Creators. Today, we have Mr. Vivek Jhunjhunwala with us. Mr. Jhunjhunwala is a partner in the Dispute Resolution Practice Group in the Kolkata office of Khaitan Co. His expertise lies in advising clients on a variety of contentious and non-contentious matters, including domestic and international arbitrations. As a partner of Khaitan Co, Mr. Jhunjhunwala is also in charge of several administrative initiatives and also conducts and organizes regular lectures and other L&D activities. We actually have a lot to learn from him and take a lot of nuggets. So without further ado, let me introduce you to the man himself. Hello, sir. Welcome to the show. And how are you doing today?
Thank you. I'm doing good. How are you?
I'm doing great, sir. Fit as a fiddle. Thank you very much for asking. And as you can see, I tried my level best to cover things about you, but it's just not possible for me to do that. So let me sort of start with this session. And I set a context after sort of introducing you for the audience. But I want it to be even clearer, and we can, I guess, clear that by understanding a complex legal issue that you recently worked upon or in your past, and describe the complexity around it and how you really approached it.
See, be very honest with you. The legal issues are never complex. It's always simple. We make it complex. We lawyers have a habit of making things complex, especially when the clients have no merits in the case or the lesser merits as per the law. Then we try to, put the complexity into issues and say that it's a complex issue which needs to be heard out. But having said that, very honestly, I cannot say that I've done much matters on any complex issue. There have been very much of legal issues, yes. Now, I remember one matter. It's not a legal issue, but a procedural issue. What had happened was during the pre-COVID days, if I can use this term, where the virtual hearing or the video conferencing was not heard of, or maybe very few percentage of being held. So our client had a arbitration, international arbitration, and the arbitration was to be conducted in London. Now the client did not have that much of funds where they could hire the London lawyers, or they could send an Indian lawyer to London for conducting the arbitration proceedings. So I spoke with the other side, and with the consent of the arbitrator, what we had done was we conducted the arbitration through video conferencing. That was first of its kind in India, in Eastern India. Now, how it proceeded, we requested to the arbitrator agreed to it. A link was made, and the link was circulated between the parties, and evidenced. To your surprise, you'll find the evidence it was a full-fledged trial, and the evidence which was conducted, it was conducted through video conferencing. Now, to ensure that the video evidence is conducted in a transparent manner and there is no biasness, so that was a problem. Now, how would you do that? Then we came out with an idea that if one of our contacts in London is present in the office of the arbitrator where the evidence is going on, so that person will be my man who will ensure that the evidence is carried out in a transparent manner. And similarly, their man would come to Calcutta, if they have anyone in Calcutta who will be in our office, and he will oversee whether the evidence is happening in a transparent manner or not. And accordingly, it was done. And we had a wonderful arbitration on video conferencing, which went up to about 7 to 8 days. And the arbitration proceedings for the first time in Eastern India was done through virtually. So that was more of, and we had the issues with regard to the venue and the seat of the arbitration, because the contract has said that the English law will apply, but it was silent on the arbitration. So we had issues on that also. So we went through that, and the lots of issues were then decided, and the arbitrator gave a go-ahead that yes, the proceedings will be conducted in English law, but the seat will be, for the purpose of the arbitration, the seat or the venue would be London, though it is conducting virtually. So that was one of the issue which I had felt. And the second issue was law relating to will. You see, what had happened was that there were very few cases which were relating to the will which was conducted in India. The law was not much explored as far as the will is concerned. So there we had this Birla Loda matter. Most of the people must have heard about it, where there was this Mrs. Birla. She had left a will, and apparently one Mr. Loda claimed that this entire estate of her was bequeathed to him, and there were issues by the legal heirs of the Birlas. They questioned the will, and we made a claim that the will was executed in a suspicious circumstances. Then the question came, who does have the covetable interest? Because everyone and anyone cannot come and fight the case. There has to be a person who has a covetable interest. Though there were some few judgments of various courts with regard to the law relating to the covetable interest, but there was no significant ruling or no clear-cut case as to what defines covetable interest. So the matter traveled up to Supreme Court from Calcutta High Court, and the law was laid down on the covetable interest that who has the locus to file, this challenge the will, how can defend the will, what is the covetable interest, how you define covetable interest. So yes, that was one issue which was resolved, in which I was one of the participants of the entire team. We had a team of around 15 to 17 people, and I was one of the participants to that. So these are the few complexities, you can say, which I overcame.
To hear that, sir. We've always heard that every case is complex in its own manner. But what you have started this discussion with, that no case is complex. It's the lawyers that try to make it, or it just happens.
Absolutely.
That's a good thing to. That's a new thing to actually, rather, I should say here. Your first thing that you talked about was the procedural complexity around the case. And in the pandemic, we saw a lot of courts begin moving towards more remote proceedings and availability. Now, because you have done this before, really, it was adopted on a mass scale. What do you think? Is this sustainable and a possible way to increase access to justice, in your opinion?
Yes, it is sustainable. Yes, it is sustainable. Absolutely. You see, this is a welcome change. It's a really welcome change. And this is one of the things COVID has made us learn. So yes, this technology can be taken forward. You see, problem with our country is that we lack in infrastructure. And the economics also of the country is not good. Now, especially for the juniors. You see, if a junior today starts his profession, he or she will not be earning much. But for him to buy the laptop, have the access to internet connection, this may become too much on them, because besides this, they have to support their family also. So now what happens is that economically we have to be good. If our economics is good, then definitely the infrastructure will become good. And once the infrastructure is become good, then definitely the juniors and everyone can have access to the legal system. So therefore, what we have to do is we have to ensure that the infrastructure is developed robustly everywhere. Now, few of the cities will have good infrastructures and few of the towns will not have infrastructure. Then obviously the access to this system will not be there. And of course, one cannot have the judiciary functioning without them. So therefore, yes, the thought is good. The government is making an effort, but yes, we require more infrastructure. Until this infrastructure is there and backed by the economics, then it becomes difficult. But with passage of time, definitely things are improving and will improve further.
So what you're saying, there's a scope of improvement, but intent is there to improve things.
The intent is there. The intent is very much there. It is just that we are coming from different background, with different culture, with the different thoughts. Now, if you have to make a 70-year-old person understand the latest technology, it becomes a little difficult. Now, you see, if I have to make my father understand the WhatsApp, the messenger, now the telegram and everything, it becomes difficult for the man to understand this technology. Rather than it becomes easier for a person who from the very early stage, he's working with technology. So yes, there are challenges, but eventually, since the intent is there, the challenges will be overcome.
That makes sense. That makes sense. Considering your experience, Mr. Jhunjhunwala, and the position where you are, I guess this is a very logical question that I will be asking now. Uh, how would you rate the current legal system's drive towards encouraging access to justice? We hear a lot argument around this, and is there a tangible movement in closing the justice gap? Because the fact is there is a gap, and I mean, what's your take on that as well?
Yes, yes, absolutely. The judiciary is trying its level best to, put the system in place, give access to the litigants, to give access to the lawyers, to give access to everyone, the advantage of the technology. You see, but I have one thought on that. Instead of coming from the top, like making your Supreme Court well equipped with all the technology, making few of the high courts well equipped with the technology, it would be better if we have the equipment, if the district courts are equipped with all the latest technology, with all the infrastructure, because you see the root of the case starts from a district court. The people have accessibility. There are more people who are accessing to district court. Today, if I have a case, I have to approach to a district court. Then it comes to High Court and then to Supreme Court. So if my district court is not equipped, then obviously there is no advantage of the technology. I am not getting any advantage of the technology. So first the district court, the hygiene, the district court infrastructure, the rooms, the filings have to be first improved. So once it is done, then I'm sure, it becomes easier, because there are thousands of district courts in the country, whereas there are only few, say, 70, 80 high courts in the country, and we have one Supreme Court. So if the district court is maintained and if infrastructure is adequately provided, then I'm sure that this system, this advantage, people at large will get it.
I mean, it's again a question. Do you really, do you think that mediation can sort of also help in reducing the burden on the judiciary when it comes to, mediation versus litigation?
No, I don't think so. That's my personal view. I don't think so. In fact, it is creating more time. It's actually creating more time. It's making it more complex and delaying the justice, because no party will mediate. But if you take out the 100 mediation cases, I'll tell you the success rate is probably 5%. Not much. It goes back to the court again. And in the process, what's happening, we are spending money on time and money on the mediation also, and again going back to the court for the same thing. So mediation, according to us, is not going to help. It is perhaps because of our nature also. We, as a human being, we have a tendency to say every time that we are correct and the other side is wrong. So until that thought process goes that, yes, whatever issues, let us settle across the table, keep the ego aside, and we come to a win-win situation. That is not happening. So mediation, according to me, is just a totally wastage of time and money.
What you're saying is rather of making it easy, mediation is actually adding more time and finally reaching the litigation stage again.
Absolutely correct. I've done many of the proceedings where have been my matters have been referred to mediation, and I told my junior that don't worry, you go earn your fees and you're coming back to the court.
So I guess it's still will remain, I guess, for a long time, the alternate dispute resolution itself.
Yes.
Brilliant. Thank you very much, sir. I mean, very recently we had a discussion about mediation and arbitration a lot, and I learned something else. But today it's the other side of the picture that I'm looking at, and I'm very glad. I guess our viewers can also take a lot of nuggets out of this session. And we are also, while you were talking, we are also talking about a lot of integration of technology into the legal space. That is legal tech. And ironically, pandemic brought a lot of positive things with it, which one of which is, of course, legal tech. And Asia is now finally in the middle of it. In this era, what are the most commonly tools for you to ease the process?
Yeah, the tab, I use a tab, I use my laptop, and there are lots of search engines which are available on the web, on the internet, where you can, you just put a query, you get a various answers to that. You have any issues on it, then you can go through it. There are legal dictionary. Now I don't have to look up on my shelf to open a dictionary. I simply type the word, and there, the meaning comes out. That 3 4 meanings, one can take whatever to its liking, they can use it. Then there are lots of websites which are there nowadays. With the advent of technology and with the accessibility of technology, what happens is that any decisions which you take, any decision is taken by the government, are analyzed and put on the net. So you can have a look at it, you can have your thoughts on it, you can deliberate on it. And secondly is that there are lots of decisions which comes out in high court or Supreme Court. They are also analyzed and put on the website. These are things come. So this is a basically a blessing in disguise. The internet and the technology combining together has come out with a, so there's so many options now one can go through it. So yes, it definitely helps. Now what happens is that the e-filing system which has also come, the e-filing systems are good, have become good. So you can, instead of going to the court or the department physically, you can do the scan it, use the PDF form, and you can file it. Then there are systems where you can prepare your own brief, colorful brief, by marking on the there's lots of software which has come by. You get to take the advantage of software whereby the indexing is done, the marking is done, the highlight portion is done. And one of the most important parts is this reminder thing. I really love this reminder, where you don't have to now keep anything in your mind. If you want to meet someone at 3 o'clock, like the way we have arranged our meeting, 3 o'clock, 5 minutes before that, a buzzer comes out that here 3 o'clock you have a meeting. So you sit down for a meeting. So one cannot forget that. So these are the advantages which one has got.
I mean, that's right. And I mean, to add on, technology is always good when it works. So, yeah. I mean, so far this has been a great session, Mr. Jhunjhunwala. We actually witnessed a lot of different side of different concepts, which we, I guess, were on the other side of it. My last question was actually about time management, but I want to add few more something else to it. Uh, there are a lot of young professionals and students who watch our session. So, what are your suggestions for them who are trying to make big in the industry? And if you can also add time management mantra of yours in that, that would be highly appreciated.
Oh yes, this is my favorite subject, time management. I often give my this pravachan to my juniors that time management is very essential. You see, I tell you, with the advent of the technology and everything, time management has become very easy. All you have to do is just every day morning when you get up, you have to analyze yourself, what are the works which you have to do, and assign a time to that. Nowadays, you can set a reminder. You have your digital diary. You can put your appointments, put your tasks to do on the digital diary. You can then assign the matter and work in a systematically way. And I say, suppose you have a, yeah, one can always decide on a time. If you are doing a particular matter, you know that a matter will take 3 hours time. So you just mark yourself for 3 hours time. And thereafter, again, you can mark your time for the other work also. So it is, you can divide it in the way you want it. Only thing is that your thought process has to be very clear. So if you just follow the basics, the time management can be done. Time management is not something which is very complex or which is very unique. It's very easy. One has to have the concept should be clear, that I have to do this within this time and the other work within a particular period of time. Then you can easily do it.
I mean, that's really wonderful. I don't think I should add anything to this, but recently I also learned this that time is money. I always used to say, but I got to know that time invested is money in any profession. So that is a beautiful way to look at it. Thank you very much, Mr. Jhunjhunwala, for joining us for the session today. I really appreciate you taking some time out of your busy schedule and giving it to us. Hope you also enjoyed the session.
Yes, definitely. Thank you so much. Thank you for having me. Thank you so much. I also enjoyed thoroughly this session. It was pleasure.
Really, it's my pleasure to hear that coming from a personality like you. And we look forward to having chat with you again in the future on some other trending topics in the international legal industry. And
Absolutely.
for our viewers, if you like this chat with them, which I'm sure you did, I want you to like this video, to share this video, and click on that red button to subscribe to Click Away Creators YouTube channel to appreciate what we do. And you have more coming in from legal industry leaders like Mr. Vivek Jhunjhunwala. This was Sagar for Let's Talk World, signing off, everyone. Thank you very much.